Right. Ooh, powerful. Good evening, ladies and gentlemen. I would like to welcome all members of the public, councillors, parish representatives and officers to the Planning Committee. This meeting is being streamed live and it is capable of repeated viewing. Could I ask everyone to note the fire safety instruction that on hearing the alarm you should leave the building by the nearest marked exit and congregate at the assembly point in the car park. Also, please switch all electronic devices being used tonight to silent. My name is Councillor Philip Minor and I am the Chair. On my left is the Vice Chair, Councillor Martin Cuthbert. The co-opted parish councillors are situated along the second row of benches. Members of the Planning Committee sit on the front row of benches and only those councillors who are members of the Planning Committee are entitled to vote. For clarity, as we go through the agenda this evening, members of the committee will be permitted to speak for up to 5 minutes on each item. Any other members and parish councillors will be permitted a maximum of 3 minutes to speak with permission from the Chair. May I remind members to declare any pecuniary or non-pecuniary interest and the nature of the interest at the beginning of an agenda item, and that on declaring a pecuniary interest you are required to leave the meeting when that item is considered. There should be no interaction from the public areas at any time during the meeting. Members of the public invited to speak on tonight's applications will only be permitted to speak for 3 minutes if they have indicated to do so in advance as a representation or an applicant agent on specific applications. Requests to speak should have been received by the clerk by yesterday at 4 p.m. In the event of a disturbance, such as calling out from the public area during the meeting, a request from the Chair to be quiet will be given, but if the problem persists, any persons interrupting the meeting will be asked to leave. If necessary, the meeting will be adjourned to allow this to take place. So, the first item on tonight's agenda is item number 1, and that is apologies for absence. Mrs. Zoe Borman, have apologies been received?
Yes, thank you, Chair. Apologies.
Okay, right, thanks for that. Declarations of interest, item 2. Are there any declarations that need to be made at this point? No? Right. Item 3 is the minutes of the meeting of the Planning Committee on the 16th of the 9th. Are the minutes of that Planning Committee agreed? Agreed. Councillor Mayo.
Sorry, Chair, I may have misremembered this, but I thought Councillor Murphy had actually abstained rather than voted against the item at land at Doddinghurst Road. I'm pretty sure she did.
So that's down as an against and it should be an abstain. Right, that will need to be corrected. But with that correction, is everybody else fine? Yes, agreed. Just pausing for a moment here.
Mine's working. Yeah. Just what we like.
So are we thinking that some of the microphones are not working?
No, they seem to be working now. I don't know what that was.
Okay.
It seemed to be a glitch, but...
Do you need me to repeat that?
Yeah, just for clarity, we've just agreed that Councillor Murphy was in fact abstaining in the previous meeting instead of voting against, which was what the minutes said. Right, So we move on from the minutes of the meeting of the previous planning committee to the meat of the agenda tonight, planning applications and matters. The committee will now determine the planning applications and matters before it. Before we begin, may I just remind those members of the public who will be addressing the committee on planning applications tonight that your speech should be no longer than 3 minutes in duration and should relate purely to planning matters. When your name is called, will you please make your way to the chair provided. When you have completed your speech, the committee will debate the application and reach a decision. So, item 4 tonight is land adjacent to the Croft and Green Lane Farm, Pilgrims Lane, Pilgrims Hatch. And this is an application for a change of use of land from equestrian to residential caravan site, laying of hard standing and associated works, 4 pitches to be occupied by habitation, by gypsies and travellers, each pitch consisting of a static caravan, 1 touring caravan, parking spaces, cycling bin stores. And this is part retrospective. The application number is 2500902/FUL, and the case officer is Leanne Richardson. Ms. Richardson.
There we go. Thank you, Chair. Good evening, councillors. So, there are 2 gypsy and traveller sites on the agenda this evening. The 2 sites are comparable insofar as both sites lie within the green belt. Also relative to both applications is the concept of grey belt land, which was introduced following recent updates to the NPPF. The definition of grey belt is outlined in Annex 2 of the NPPF and is also quoted in the officers' reports. Grey belt is defined as land in the green belt comprising previously developed land and/or any other land that, in either case, does not strongly contribute to any of purposes A, B or D in paragraph 143 of the NPPF. For clarity, neither site constitutes previously developed land. What is notable is that greenbelt purposes C and E, which relate to encroachment in the countryside and assisting in urban regeneration, do not feature in this definition. There have been recent successful appeal decisions whereby permission has been granted for development on grey-belt land, which was previously refused on the basis of being inappropriate development in the green belt due to the impact on purposes C and E. So for both schemes, an assessment needs to be made as to whether the sites qualify under the definition of grey belt and whether the sites strongly contribute to green belt purposes. If a site represents grey belt land, then very special circumstances need not exist. Whilst there are similarities between both applications, they are different sites and must be assessed on their own merits. Intentional unauthorised development is a material consideration where significant weight should be afforded in the determination of planning applications and balanced against the merits of the schemes. The site is located to the south of Pilgrims Lane, where access to the site is taken from. Residential dwellings and a nursery containing a number of glass houses lie within close proximity to the site, to the north. Pilgrims Lane is a private road and a bridle way. A public right-of-way runs along the western boundary of the site. The next few slides just show some photographs for context. So this is the nursery site, which is just to the north of Pilgrims Lane. This was taken for, well, this is just shows the layout of the site as existing, which was taken from the public right-of-way to the west. This slide was taken just further down the public right-of-way with the site to the right-hand side of that image. So, in terms of the application, retrospective planning permission is sought for the change of use of the land to form 4 pitches to be occupied by gypsying travellers. Each pitch would consist of 1 static caravan and 1 touring caravan, along with the lane of hardstanding. A band of mature trees run along the northern boundary of the site, and soft landscaping is proposed along the boundaries of each pitch, the final details of which will be secured by condition. So both the MPPF and the planning policy for traveller sites considers gypsying traveller sites to constitute inappropriate development in the Greenbelt unless very special circumstances exist. The MPPF states that development is not inappropriate where it utilises grey-belt land, where there is an unmet need for the type of development proposed, where the site would be in a sustainable location, and where the development meets the golden rules. In terms of the first point in relation to whether the site utilises grey-belt land, the site would be viewed against a backdrop of an established hedgerow to the north and is surrounded by sporadic residential dwellings and a nursery with a number of glass houses. So as set out in the officers' reports, officers consider that given the site's location, its character and context and the relatively small scale of the development, the site does not strongly contribute to the purposes of the Greenbelt. Officers are therefore satisfied that the site meets the framework's definition of grey-belt land and should not be regarded as inappropriate development in the Greenbelt. If members accept that the site constitutes grey-belt land, this would not give a green light to gypsying traveller development across the borough's Greenbelt. The second point relates to whether there is an identified unmet need. Following changes to the planning policy for traveller sites definition of gypsying travellers, more households now qualify under the revised definition. Following this change, the Council updated its gypsying traveller need assessment, which confirms that there is a significant unmet need of gypsying traveller sites in the borough. The lack of available sites has also been identified in recent appeal decisions. The development would therefore assist in addressing a shortfall of accommodation needs for the traveller community. This is a matter which weighs significantly in favour of the development. The third point relates to whether the site is within a sustainable location. The site is located outside of the settlement boundary. However, it is widely accepted that gypsying traveller sites are not typically located in areas towards the outskirts. Are typically located in areas towards the outskirts of settlements and not directly within the most built-up areas. This is a view also taken by inspectors in appeal decisions. At the heart of the MPPF is a presumption in favour of sustainable development. Paragraph 110 of the MPPF states, development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes. It goes on to state that opportunities to maximise sustainable transport solutions will vary between urban and rural areas, and this should be taken into account in decision making. Paragraph 115 of the MPPF prioritises sustainable transport modes and requires there to be no significant impacts on highway safety. In this case, the site is relatively close to the A128, where there are bus stops providing a number of services to Brentwood, Epping and Shenfield. So when taken into account PPTS and the MPPF, which are both material planning considerations, and taken into account gypsy sites are often located in the countryside, officers considered that the location of the site would be acceptable in terms of its sustainability. No objections have been raised by the highway officers on sustainability grounds. With regards to the fourth point, the golden rules, as referred to in the NPPF, relate to affordable housing, necessary improvements to local or national infrastructure, and provision of new or improved green spaces. In accordance with the NPPF, the golden rules do not apply to traveller sites. If members' view is contrary to officers in terms of whether the site meets the Grey Book definition, then a case for very special circumstances will need to be demonstrated. Officers do not consider that there is a need to demonstrate very special circumstances in this case by virtue of the site meeting the definition of grey belt, and therefore is not in further development. However, the following case has been put forward. The site is occupied by an extended family who are Irish travellers, and officers are satisfied that the occupants would meet the gypsy status as defined in the revised PPTS. The applicant has submitted a personal circumstances statement in support of the application, which has been evidenced by medical records. It details that family members are living with lifelong medical conditions which require constant care and management. Other personal conditions have also been identified. It is essential, therefore, that the family have a settled base so that they are within easy reach of medical facilities, so that their conditions can be managed effectively and for the children to continue their education. The personal circumstances of the applicants and extended family weigh in favour of the development. Policy HP10 of the adopted local plan is relevant in dealing with gypsy and traveller sites. It states that planning permission on unallocated land will only be granted subject to compliance with a set of criteria. The report has assessed the relevant criteria and concludes that the requirements of Policy HP10 have been met. Paragraph 28 of the PPTS states that if a local planning authority cannot demonstrate a 5-year supply of deliverable sites, local authorities should consider how they could overcome planning objections through the use of planning conditions. Conditions have been imposed to secure final details of drainage, hardness of landscaping, confirmation of water supply and a lighting strategy. The NPPF makes it clear that any harm to the greenbelt must be clearly outweighed by other considerations. In this case, there are a number of matters which are considered to weigh significantly in favour of the application. The cumulative weight of these other considerations clearly outweigh any harm arising from inappropriateness in the greenbelt. So to conclude, the applicants meet the definition of gypsy and travellers. The proposal meets the definition of grey belt and does not represent inappropriate development in the green belt. There would be no significant harm to the character or appearance of the area. There are no technical objections that would justify refusal of planning permission. And the development would assist in addressing the shortfall of accommodation needs for the traveller community. Thank you, Chair.
Thank you. Right, the next person to speak is an objector, Mr. Mills, Wayne Mills.
I'm Wayne Mills and live next to the field in question. At 19, I had a bad accident and made me wheelchair bound, and then at 34, developed late stage 3 cancer. Then at 52, I got a life-threatening infection that has meant being in and out of hospital by the aid of ambulances for a year out of the last 2. The use of ambulances is now very hard. I moved into Pilgrims Lane 6 years ago to get peace and harmony away from the hustle and bustle of the busy towns. The reasons I'm highlighting these points is because the travellers are highlighting health issues, and I too have many of my own. I used to often use the lane for my exercise by going up and down and pushing myself and keeping strength in my arms and getting my heart pumping. And since the travellers have moved in, this has become impossible. Since the travellers moved in illegally, I've been unable to use the lane as it has been severely damaged from the 20 number lorries that delivered hardcore for the travellers when they illegally ripped up the field, pulled up trees and damaged the hedgerows. The travellers also have 3 to 4 trucks that constantly go up and down the lane 6 to 7 times a day, increasing the traffic. Since the travellers moved in, I've become a prisoner in my own house as I can no longer use the lane for exercise or look into the fields for the wildlife, which has caused me a mental breakdown and having dark thoughts, and I'm now having been prescribed sertraline antidepressant medication. Prior to travellers, there was badgers, bats, birds, which were nice to see and hear. Since the travellers moved in, destroying the field and the hedgerows, there's been no evidence of them. We have also had the travellers' vehicles shining headlights into our property in the early hours, of which we photographed and sent to yourselves. I'm sure that someone in here will mention their human rights, which is right, but I've also got them as well. I'm not prejudiced, as my granddad was brought up by a gypsy family, and I'm proud of that. We have written evidence from the Highways Agency stating Brentwood Council do not own the lane, and that it's the responsibility of Mr Skerry, who lives at the top of it, and myself. Mr Skerry has maintained the lane for the last 30 years, and we have assisted for the last 6 years, spending 4k of our own money over and above what Mr Skerry has spent already. I therefore fail to see how Brentwood Council can give right of way in a lane that they don't own or maintain. And as I understand, no permission for the right of way has been granted for the travellers. Look, I'm begging and I'm pleading with you to take my own situation into account, and for the reasons I've given, refuse this application. I just need the lane and the field for my own insanity, my mental health issues and the wheelchair needs.
Thank you. Thank you, Chris. Have you finished, sir? Sir, have you finished?
Yeah, finished it.
Okay, thank you. Thank you for that. Right. The next person to speak is the agent, Tony White.
Thank you. Good evening. The application before you this evening for your consideration and determination has undergone a rigorous and thorough examination against both national and local planning policies by your planning team. I wish to focus on 2 areas of that assessment which often arise as a point of discussion in committee, and I think your officer has probably just covered a lot of what I'm about to say. The first being inappropriate development in the Greenbelt, which until December 2024 revisions to the National Planning Policy Framework were assessed against a very narrow list of exceptions under Chapter 13, Protecting the Greenbelt, and or the personal need of the applicants known as very special circumstances. The government, in an attempt to bring forward development to meet the identified needs of all sectors of our communities, introduced an additional criteria-based set of exceptions under paragraph 155, often referred to as grey belt, but this being just one element of the assessment of paragraph 155, with applicants needing to also satisfy 155B and C. In order to meet the exceptions to inappropriate development under paragraph 155, the application site is put through a series of vigorous planning assessments against this national planning policy alongside local plan policies, and then further material facts related to the site itself. The case officer sets out their assessment from page 10 onwards in their report to committee, with the summary conclusion at page 13, concluding that the site is not inappropriate development when correctly assessed against the policies, and the site passes therefore paragraph 155. This is a significant point in favour of granting planning consent. The second element I wish to focus upon is the statutory requirement the council has to demonstrate an up-to-date 5-year supply of sites as set out at paragraph 28 of the planning policy for traveller sites. And in this instance, we can see at page 13, 6.28 and 9, it is confirmed that the council cannot currently demonstrate an up-to-date supply for the reasons the officer set out in her presentation to you. This gauges what is referred to as the tilted planning balance in favour of granting consent, which is paragraph 11D of the National Planning Policy Framework, the presumption in favour of sustainable development and the use of planning conditions to bring forward development to meet the need shortfall. You can see the officer's sustainability summary at 6.31 of the page 13, where they explain the approach taken to gypsy and traveller sites, considering the PPTS and MPPF, resulting in the conclusion that the site is considered sustainable. It is not possible to convey to you this evening, in the short time allotted, the depths of examination undertaken to assess the site and reach the planning balance conclusion that consent should be granted. But I can assure you all that your officers have done a very thorough assessment of the facts and reached the outcome that planning permission is recommended to be granted subject to imposing conditions. I thank you for your time and allowing me to speak this evening, and I hope you can support the officer's recommendation to approve with the conditions as set out and agreed. Thank you.
Thank you for that. Thank you for that. Right, so we've got, of the non-committee members, do you have an order in which you'd like to speak? Councillor Russell, Councillor Wagland, does it matter? You can both speak, but who? Councillor Russell.
Thank you, Chair, for allowing me to speak. Although I'm not a member of this committee, I would urge the committee members to strongly consider refusing this application for several reasons. Pilgrims Lane is an historical lane that dates back to the pilgrimage to Canterbury. Highways concerns. This site is accessed by a bridle path that is unsuitable for vehicle traffic. It is privately owned under adverse possession and has been maintained by the owners for approximately 30 years. Consequently, there are no speed restrictions on this path, which is often used by horse riders, cyclists, pedestrians and individuals with mobility issues. Approving this proposal will contravene paragraph 116 of the National Planning Policy Framework. Furthermore, policy HP09E stipulates that permission can only be granted if there are no adverse impacts in terms of highways access and vehicle movements. Additionally, policy HP10, as stated earlier on, 127B states that planning permission can only be granted if there is a safe and convenient vehicle access to the local highways network. I have a signed affidavit witnessed by solicitors, which is in the hands of the Councillor Aspinall there for you to have a look at if you need to. Greenbelt. The applicant has not provided sufficient evidence to support the claim that this site qualifies as grey belt status, as it is not previously developed land. Images from 2006 show an area approximately 55 square metres where timber shed and storage were present, but aerial photographs do not demonstrate uninterrupted use over the years. PDL excludes fixed surface structures that have blended into the landscape. It is important to note that proposals encompass 4,355 square metres, which is nearly 80 times the original area claimed as permitted development. I will share these photos with my colleagues on the back bench here. Unmet need. The local plan was adopted in 2022, but in 2024 the government changed the requirements. However, the planning policy for traveller sites provides guidance to local planning authorities and encourages them to plan for sites over a reasonable timescale. I understand we have currently allocated 25 pitches, and it is essential to determine what is reasonable in terms of a timescale. The government's actions have significantly impacted our local plan, and it's understandable that there is confusion regarding planning policy and its relevance in this case. Nevertheless, I would remind committee members that we must assess each case on its own merits and not be influenced by other applications that are under appeal. Addressing these appeals is a responsibility of the Council that must be accounted for in our budget, and I'm confident that residents would prioritise contesting these applications. In conclusion, it is time for this Council to take decisive action and make serious effort to establish a timeline for provision of gypsy and traveller sites, demonstrating that we have a coherent plan in place. Overall, in conclusion, Inappropriate at the green belt development, grey belt justification unproven. Intentional unauthorised occupation, contrary to national policy. Invalid biodiversity evidence, no lawful baseline or net gain. Significant landscape, environmental and highway harm, conflicts with local planning policies, MGO2, HPO7, HP10 and NE01 and HP09. I request that members refuse this application, alternatively deferring it pending a proper ecological survey and biodiversity net gain assessment for the caravan site and a documented equality and welfare assessment in accordance with the case law, allow measures of mitigation by condition in consultation with the neighbours. Thank you.
You had more than you should have had there, but couldn't find a way of stopping you. Sorry. Anyway, so Councillor Wackland, do you want to speak next?
Thank you, Chair. And No, I quite understand, Chair. I'll probably retrieve you some time. Chair, thank you for hearing me. Notwithstanding I don't sit on the committee, but I am the county councillor for the area. I had some concerns about the report in relation to what it said from the Highways Authority, which I thought was ambiguous. I have therefore gone back to the relevant officers and have had the following. Firstly, they tell me I am correct that the applicant would need permission for vehicle access from the landowner. After all, says the correspondent here, who is senior planning officer, this is a bridleway. And as you probably know, that means it's for the use of pedestrians, cyclists and horse riders. It's specifically not for vehicles without a permission in place. In terms of gaining permission, however, I would have to defer to planning authorities in relation to matters non-highways. However, as I see it, the applicant could gain planning consent without vehicle access permission, provided that they had permission for that. I think that's really important because it was possible to read the report in a number of different ways, and it seems to me to be a key factor. I'm also concerned that I think there were land ownerships which probably ought to have been the subject of certificates or notification under proper due process in relation to the lodging of an application. I would add that we now have a clear understanding of what the occupation would mean because of the illegal unauthorised works, in particular to the lane, so we can see very clearly, and I would like to see that at the least evaluated with the benefit of the information from those people who actually, it appears, have the ownership of the land. So this should, in my view, be deferred at least for that, so that those matters can be properly evaluated. Otherwise, the special circumstances urged by the travellers seem to me not to be persuasive in material planning considerations. Thank you very much indeed, Chair.
Thank you. Thank you, Councillor Wackland. Right, sorry. So, Councillor, those are all the non-committee members that I've got down to speak. Councillor Gelderblom, you're obviously on the committee and you're a ward councillor. You can speak now if you want to, or you can speak later on. Obviously, you're on the committee, you can speak at any time.
Thank you, Chair. I'd like to thank the officers for bringing this to the committee. As I know from previous experience, you know, these cases can drag on for years, and I do appreciate that. I do have a few concerns about in relation to the fact that obviously you've been communicating with the traveller communities over sites that might be applicable, and I just wondered if you'd had any communication with the settled community. That's one question I would like to ask. Obviously, I have concerns about the grey belt status, as I can only put it in simple terms, but up until 2 months ago, it was very much a green field. And the work that's been carried out as well without permission is very concerning as well. The movement of traffic on and off the site, I know can be quite busy at times off of a traveller site due to the amount of vehicles and cars and the businesses that might be run from there. Also, the conditions about the sewerage and the drainage, I don't feel there's enough detail in the report about that, as I know that can cause some trouble. And also evidence of the traveller status and the medical conditions, I don't think that's as clear as what it could be. And also about the site, but it's difficult to get to amenities from the site, obviously, because of the access as well and through the country lanes. And that's for the moment. Thank you.
Thank you. So there was a question there about the conversations that we've had with the settled traveller community. That was the question you asked, wasn't it, Councillor Gold? Is there an officer who'd like to make a comment on that?
So through the local plan process, obviously, when we were looking at allocating sites in the local plan, that was subject to a public consultation with all residents, businesses and stakeholders in Brentwood. So, excuse me, so that would, that's usually the format in which we discuss site allocations. Obviously, when it comes to individual planning applications, they're subject to consultations, which again, any and all members of the public are able to correspond and write to us with. So that's probably as far as I can say in terms of those, any discussions that we would have had.
Thank you. Could I just ask a further question? When you say public consultation, is that are residents written to personally, you know, in the surrounded area, or is it just purely just, you know, you're putting out consultation on the website?
So as far as the local plan is concerned, that's subject to a consultation plan. I wasn't here at the time, but I don't think every single resident was written to separately, but there will have been website, newspaper, all those types of things. In terms of the planning application notifications, I might ask Caroline just to pick that up.
Just to say, we were. I caught a glimpse of ourselves. We were hiding behind the previous presentation, which is being fixed, I think. We'll carry on. We have the next person who's indicated to speak is Councillor McShane.
Yeah, sorry, I've got the application. I just wanted to confirm this isn't in the local plan. It is at the moment Greenbelt. The surrounding area all around it is Greenbelt, and it was actually, there was a stop notice only on the 2nd of August, which is 2.5 months ago, to stop all this development. I just wanted to confirm all that. That's true, isn't it? It's not Greybelt at the moment.
Some officer wants to come in on that?
So yes, thanks, through Chair. So that is correct. There was a stop notice issued when caravans were being moved onto the site. Greybelt is identified through the tests that the officer went through in the presentation. So yes, it's within Greenbelt, and within Greenbelt there is the concept of Greybelt. Correct.
That was all, Councillor McShane. Okay, Councillor Naylor.
Thank you. Two things. If we go to 6.24 MPF paragraph 155, where it says development in the Greenbelt should also not be regarded as inappropriate where the following apply. And then if you go to C, it says refers to 110 of the MPFF which is about promoting sustainable transport. If we then go to 6.3.1, it then says that this site is not suitable for sustainable transport, but then doesn't give any direct reasons when it mentions PPTS and NPPF. So can I take you on that one before coming to the next point?
Anybody wants to? I would comment, and I was asking questions in the chair and vice chair meeting. It does seem that paragraph 6.31 is going almost all the way to saying that this is not a sustainable location without actually saying it. And obviously, it wasn't. If it wasn't a sustainable location, this site would not meet NPPF paragraph 155C. But any officer wants to comment?
Yeah, there is a presumption in favour of sustainable development and sustainable transport nodes in terms of the NPPF. And the NPPF does seek to achieve sustainable development, but it does specify that there would be some differences between urban areas and rural areas. It's accepted that gypsy and travel sites being being outside of a settlement boundary would essentially not be the most sustainable sites. However, this has been picked up by inspectors, and there are bus stops within the vicinity which are walkable. And again, this point has been picked up by inspectors in their appeal decisions. So it is accepted that most gypsy and traveller sites being outside the settlement boundary would not be the most sustainable locations. But on balance, and in considering inspectors' appeal decisions and recommendations, given that there are bus stops in the locality, there are alternative options, and on balance, it's considered that the scheme is acceptable on sustainability grounds.
Thanks, Chair, for conveying my first point. But before I go to my second point, might I just come back on this bus stop thing. If the bus stop's half a mile away and the bus comes every 2 hours and it costs, I don't know, £3.50 to go to the high street, is it still sustainable?
It comes back to it's not the most sustainable, but there are alternative options other than the use of the private car.
Seems a bit thin on the ground. I think there is some design harm that goes against the MPF principles which seek to secure high quality design. What is the high quality design that outweighs other considerations?
I think by their very nature, design of gypsy and traveller camps and pitches are of a set type, and again it's accepted by most appeal inspectors that a pitch will be set out in a certain way. Whether you consider that as a design principle or not is open to interpretation, I guess, but by the very nature, a pitch will normally contain a travelling a mobile home and a travelling mobile home and a day room. That's the standard, and that's accepted pretty much by all authorities and by inspectors.
Great, thank you.
Councillor Mayor.
Thank you, Chair. Officers are quite welcome to contradict me here, but in my judgment, if this had come to committee 12 months ago, this would have been a Greenbelt application and there wouldn't have been unmet need and we wouldn't even be discussing it. Okay. Greybelt definition appears in the papers to be an assessment made by the officers. So, if I could ask, what legal advice was sought on the definition of Greybelt? And if there was any, what was its conclusion?
So no legal, there's the interpretation of grey belt is set out in policy, national policy. There doesn't need to be, in terms of legal interpretation, that is done through the courts. That's evolving, so we don't, as officers or as a council, need to take specific legal advice as to what is grey belt. It's set out in policy, and then there's interpretation of it.
So just to be clear, there hasn't been yet a legal judgment on grey belt that any of the committee can actually refer to in terms of the strength of the assessment of the council officers. Is that fair?
Thank you. The green belt, I'm legal solicitor. The definition of grey belt is within the NPPF. That refers to criteria which is a planning judgment. It's a relatively new concept in terms of the NPPF, and it wouldn't be untrue if there was a lot for me to say there was some case law going through the courts with regards to that, which is not unusual when the government decides to change the material considerations in terms of the NPPF. But the grey belt is defined within the NPPF, and that is a planning judgment.
Okay, so finally, to clarify my concern here, we don't have any case law to refer to. We don't have a robust definition, in my opinion. And we are, if we take a judgment to approve this evening, we are effectively setting a precedent for the definition of grey belt within this borough. That is my view, and I'm not comfortable with that as it stands.
Yeah, I've got a couple more people who are down to speak. We're conscious of that. I think there's some comments I'd like to make about that, and I think with the best will in the world, and this is not the officer's fault, with the best will in the world, if you look at the wording of the government's grey belt legislation, it is an absolute mess. And that might be my opinion as an individual, as a member of the planning committee in Brentwood. I was very struck to discover the comments that were made by the policy director at the Town and Country Planning Association, Dr. Hugh Ellis, a year ago, who was asked whether he thought that the Greenbelt definition was clear enough for planning officers to implement it, and he said emphatically it is not. He also said that in his opinion there was no effective way of adding to the Greenbelt definition that would make it operationally effective for planners on the ground. So he also said that he thought that the grey belt concept fundamentally undermines the purposes of the green belt. Those are obviously strongly expressed words, particularly coming from somebody like that, the policy director of the Town and Country Planning Association. But I think they're very important words for us to hear. The problem that we've got at the moment is we've got two sets of guidelines that we need to be thinking about here. One of them is in terms of what are appropriate locations in this borough for gypsy and traveller sites. And we're struggling with that because the council is going to go through a process. It's got commitments to provide new gypsy and traveller sites. It's going to go through a process of identifying those sites, but it hasn't yet done it. So we haven't got an assessment of where appropriate sites in the borough are. That's the first thing. And the second thing is in terms of the green belt and the grey belt, the council is again going to go through a process to look at the green belt across the borough and to work out where the grey belt, if any, is. But again, the council has not gone through that process yet. These are both processes which are in hand. It's appropriate they're in hand. It takes a while. You can't do it overnight. Somebody moves the goalposts on a national level. No local authority can magic up an answer overnight. So it's not inappropriate not to have the answer yet, but we're being asked to make a decision without having the guidelines, without having the yardsticks that would be very helpful for us to help us make those decisions. That is a big problem, and that's where we are. I won't go any further at this point. I'll come next to Councillor Baldock.
Thank you, Chair. Councillor Naylor just now mentioned that sustainable transport, and the officer said, well, I think you implied that they'd be able to use their own vehicles. But I think we just established a few moments ago that they will not have vehicular access because they can't use their vehicles on the bridleway. So they can't use their own cars or vans or any other vehicles legally, and they can't get to a bus stop. So how is that sustainable transport? My other concern is there's no real strength of mention within this planning application of the intentional unauthorised development, when I'm looking at other cases where that's given a lot more weight, and there doesn't seem to be a lot put to that here. And it's not been as I see it, the WMS, it's not been overruled as yet. It's not been consulted on. So I think a lot more weight should have been put to that as well. Thanks.
Just to come in on that particular point, the issue of weight is for members. Exactly. And no court will generally interfere with weight. A court will generally only interfere if you've missed a material consideration. But the weight to be given to a material consideration is very much left with the members of the planning committee. In terms of the written ministerial statement, you are correct. It is still in place.
Councillor Gelderblom, do you want to come back?
Thank you, Chair. Just wondering about the pitch size. Is it a standard pitch size? Because obviously the site is larger, and I'm just wondering, is there you know, a plan that Traveller Sites follows for the pitch size?
As an officer, want to comment on that?
Not to my knowledge, there's no standard size in terms of the coverage of the area. What it normally consists of is a mobile, a tourer, and a day room. They're the three components that would normally make up a pitch.
So there's no size stipulated for a mobile tourer. Thank you.
Councillor Barber.
Thank you, Chair. A couple of things, I'll be as quick as I can. First of all, 6.20 and the definition of the criteria for Greenbelt. In all honesty, you could pick a field in lots of agricultural areas around the borough, and you could claim that losing that field would not in itself damage the Greenbelt. But if you did it on multiple field after field after field, you would soon have that effect. So that's how I'm going to interpret it. From my point of view, this is not a grey belt site, it's a green belt site. If you look at the aerial photographs, that's clearly demonstrated. A couple of other things. Under 6.4 on page 16, it says that basically the planning policy for traveller sites, the government's overarching aim is to ensure fair and equal treatment for travellers in a way that facilitates their traditional and nomadic way of life, whilst respecting the interest of the settled community. I would suggest that anyone who heard Mr Mills speak earlier this evening would understand that many of the settled community don't share the conclusion that that has been delivered here with this application. I also think that the travellers are entitled to the same high quality of buildings and homes that other people enjoy, and to see so many things conditioned within this application. Sewerage. I mean, it's a fairly basic thing, and let's be honest with you, we all know of sites around Essex where sewage is actually leaked into streams and is not properly dealt with. So it is important that on all applications, wherever the background of the people bringing them forward, that sewerage is properly handled. There is nothing wrong or discriminatory to say that. If you look at HP10, because I don't accept this is grey belt, it says that the site should be well related to existing communities and accessible to local services and facilities such as shops, primary and secondary schools, healthcare and public transport. Anyone who knows the site will know that it's very difficult to get into Brentwood from there or anywhere where those are delivered as services. D, there is no significant adverse impact on the intrinsic character and beauty of the countryside. I think everyone would agree that that is not true. The site provides, under G, the site should provide a suitable living environment for the proposed residents, and there's no significant adverse impact on the amenity of nearby residents. I think you've just heard that that's not the case. And finally, 2, sites within the Greenbelt will need to demonstrate very special circumstances which clearly outweigh the whole of the Greenbelt and any other harm in addition to the criteria A above. And in my view, we haven't heard anything tonight that demonstrates the fact that the personal circumstances of the individuals, for whom I have every sympathy, yes, should trump the decision about whether this should be allowed in the Greenbelt. So for me, I will be voting against this application tonight.
Thank you, Councillor Barber. Yeah, I very much agree with those points. I also had looked at HP10. I think it's pretty open and shut. You can try and avoid the conclusion, but it's pretty open and shut that what is being said in paragraph 6.31 in terms of, I mean, the point here, the important point to emphasise here is this is not, what's being said in paragraph 6.31 is not as a consequence of an objector saying negative things about this site. This is as a consequence of the applicant themselves submitting details on the proximity of a number of local services which would not be easily accessed by foot due to the lack of footpaths within the immediate area, and the officer themselves saying that this conflicts with local and national policy in respect of achieving sustainable transport locations. So when it comes to looking at HP10 and what HP10A says in terms of the site being well related to existing communities, accessible to local services and facilities, shops, primary, secondary schools, healthcare, it doesn't follow HP10. It fails HP10. I agree with you on HP10D, and I also agree with you on HP10G. And what we've just heard from the immediate neighbour to this site demonstrates the issue as far as HP10G is concerned. We also know that the written ministerial statement of 2015, although it's 10 years old, is still applicable, and it is applicable as far as this site is concerned. This is a site which is a textbook example of unauthorised development, which is what that written ministerial statement refers to. And I personally would like to give that a great deal of weight. And I would also personally like to give a great deal of weight to the defence of the Greenbelt in Brentwood. As I said earlier on, this council is aiming to come up with yardsticks to measure what is Greenbelt and what is Greybelt, what makes sense as far as Greenbelt and Greybelt is concerned in Brentwood. We haven't yet managed to get those yardsticks. I'll come to you in a moment, Councillor Rigby. So I don't think we have a clear steer in terms of Greenbelt and Greybelt, although the officer is obviously saying that in the officer's view this is Greybelt. I think, and this is with full respect to the officer, the situation that we find ourselves in as a committee at the moment is to essentially have to guess whether this is Greybelt land or not. The officer is saying it is, but where is the strong evidence that this committee has in front of us that shows that it's Greybelt land? We don't have that. We have some very, very wording, convoluted, logically nonsensical, frankly, things in national policy documents which have only lately come out. We've got some very critical comments from planning professionals in terms of those wordings. We don't have the evidence on gypsy and traveller sites in Brentwood. We don't have the evidence as far as Greenbelt sites in Brentwood is concerned. So as far as I'm concerned, I don't go along with the officer recommendation for approval. And in fact, I'm perfectly happy to move this application for refusal. I don't yet have a secondary. I'm only too happy to have a cross-party process. If Councillor Barber or Councillor McShane wants to second that. Councillor McShane? So, we have, we have the issues which have been raised are, there's various things written in different places in this document. We have HP10A, we have HP10D, and we have HP10G. If this is as the view has already been expressed, this is Greenbelt site, we have to ask whether there are very special circumstances. If it's a Greenbelt site and not a Greybelt site, then the whole of National Planning Policy Framework, paragraph 143 applies. As far as the whole of National Planning Policy Framework 143 is concerned, paragraph C is definitely a problem as far as this site is concerned, which I will just quote paragraph C so that we have that clear in our minds. 143. And that is to assist in safeguarding the countryside from encroachment. So all of those things are in play. I'm happy to go to an officer in terms of their comments on those points which have been raised so far. We'll obviously carry on beyond that, but any officer who wants to respond. Somebody? Okay, well, shall we go to Councillor Rigby, who's indicated to speak, while the officers are coming up with answers to those points. Councillor Rigby.
Thank you, Chair. I mean, this has been an extensive debate with some excellent contributions from all sides of the chamber, and I feel, like many other members present, that I cannot support this application. I feel that the contributions, particularly in relation to HP10, are pretty fundamental, and the range and variety of reasonable criticisms offered by members and by those speaking earlier, I think is persuasive. I understand the officers' reasoning and their report, and I also understand the points made by the applicant. It's been a detailed and thorough debate, and it shows what we can achieve when we consider these things in the round, in detail and carefully, which is how a planning committee should be, and I think that weighs heavily on my decision to vote.
So, do we have an officer response on the reasons for refusal which have been so far mentioned?
Thank you, Chair. So just so we can be clear on the reasons why the committee does not accept that it's Greybelt land, then we need to go to paragraph 143 and look at A, B and D. I think everybody probably agrees that D is not relevant. Just bear with me 1 second. And then we can just go through the Greenbelt and HP10. So
the problem I've got with the National Planning Policy, the wording that's been added in is that you cannot follow that wording through in a consistent way. One of the concerns I raised at an earlier point in discussion with officers is that we're in a very strange situation. I mean, it's somewhat by the by here, but we're in a very strange situation where we simultaneously have, in the National Planning Policy Framework, paragraph 143, where there are 5 sections, and they are the reasons why we should be defending the Greenbelt, and the wording which the government has seen fit to bring out, as far as Greybelt is concerned, immediately, not when you conclude that something is Greybelt, but immediately that you ask the question as to whether something is Greybelt or not, you can only consider 3 of those 5 sections, which to my mind is utterly nonsensical. If those 2 other sections of paragraph 143 apply in the Greenbelt, and all Greybelt sites are in the Greenbelt, how and at what point do you suddenly say, no, we're not going to abide by our own National Planning Policy Framework as far as those sites are concerned? If you had a standalone definition of Greybelt and you said, right, we put this next to the National Planning Policy Framework, plug it in, you can work out whether something is grey belt or not, and then you can work out what the consequences of that are as far as the rest of the document is concerned. That's fine. We might not like it very much, but that would be fine. That's not what the government has actually done. The government has created a horrible short circuit in planning wording, which basically feeds the argument back into itself, which prevents you from coming to a conclusion. That's why, I mean, that's one of the reasons, it's not the only reason, but that is one of the reasons why I'm saying that with the best will in the world and with great respect to the officers, particularly given the fact that we haven't been able to do a survey in Brentwood and work out what, as far as Brentwood is concerned, we think is green belt and what we think is grey belt, we're essentially guessing. It's the best at this point is a guess that this is a grey belt. So, and I cannot put significant planning weight on a guess. So I'm not seeing the argument actually having been made that this is grey belt. There's an officer report, we've got various paragraphs to read, I've read it through several times. I cannot see the case having been properly made. And a lot of that, as I say, I've got a lot of sympathy for the officers, because a lot of that is because the wording that has been put out by the government is frankly not adequate to arrive at any solid conclusion. It's not the officers' fault. They're having to work with, you know, they've been given a chocolate fire guard. It's not their fault that it's not protecting us. So that's where we are. Any more comments by members? I haven't got anybody else who's down to speak at this point. Any more comments by officers? Anybody who wants to speak can indicate and we can come back to them. Any more comments by officers?
In order for us to be able to get to the green belt and why it's not acceptable under HP 10, we still need to go through why it's not grey belt. So, and that's fine if the committee doesn't agree with officers, but then it would be useful if we could hear where it would contribute to unrestricted sprawl of large built-up areas and or involve towns merging into one another. So they're the 2 points. Because the grey belt, there's two tests, there's two parts to it. First of all, you have to look at 143, and if you agree with the site itself, complying with A, B and D, then you go to 155, which is where you can then start to talk about, well, actually, is it in a sustainable location? Is there an unmet need? So the sticking point in terms of just forming a reason for refusal is making sure that the committee is clear it doesn't meet A, B or D of paragraph 143. So that would really be the sort of starting point for us to say it's not grey belt. Then you wouldn't need to go on to 155. But so if the committee can articulate how it doesn't check the unrestricted sprawl of large built-up areas or prevent neighbouring towns merging into one another, then we've got to start to say, well, actually, it's not grey belt. We can look at it purely as green belt, and then HP 10 comes into that. That's the difficulty in terms of forming a reason for refusal to say, if you're saying it's not grey belt, why is it not grey belt?
Yeah, one of the problems with that is that the first section of paragraph 143, the section that talks about checking the unrestricted sprawl of large built-up areas, which is always there. I mean, that's what the green belt is there for, and that's what it was put in place for in the first place. Are we supposed to be looking at the specific narrow site by itself, or are we supposed to be looking at the consequences of this site being something other than green belt? And I mean, one of the things that was mentioned, I've lost the point where I wrote the thing down now. There was a question in terms of. If just bear with me for a moment, I'm going to try and find something I noted. Councillor Maldrock, do you want to come up?
It sounds like we're being asked to prove that something is green belt. Surely the onus should be on proving that it's grey belt, being as grey belt is a new phenomenon. So surely, unless it can be proved, unless we can be shown why it's grey belt, such as a plan or some real clear definitions, rather than, oh, it might be, and it's very much a grey area, pardon the pun, we should assume it's green belt unless we can be shown otherwise. It shouldn't, the onus should be not that way round, not the other way round, I think, sorry.
Sorry, I haven't found the thing I noted. I know I wrote something down and I can't currently find it. I'm just going to see if I can find it. I'll give myself a few more moments to see if I can find it, because it is relevant to this. So just for clarity's sake, we've got what NPPF paragraph 143 says, and then we've got what paragraph NPPF paragraph 155 states. Just for clarity's sake, if you have a site which doesn't qualify under paragraph 155, is that saying that this is not grey belt land, it's green belt land? Can we have an answer to that? Can we have an answer to that, please?
Sorry, so you'd need to go through the 143 first of all before you get to 155.
143 takes you to 155.
It does, but you need to say, first of all, whether or not it meets 143 A, B and D. So just bear with me 1 second, because there's some helpful guidance in the PPG.
Just to say to everybody, people who are putting their hands up who aren't on the planning committee, there's a strict process as far as planning committee debates are concerned. There's a period during which non-planning committee members can speak. People have to have signed up to speak, or they're representatives of areas. Once the planning committee starts speaking, nobody else can come in. And that, unfortunately, is the case, even if people who aren't on the committee have answers to questions which the committee would dearly like answers.
Chairman, sorry, point of order. That's not correct. There's a point.
What part of the Constitution? Council.
By way of the Constitution, it clearly states that members of the office council that are not on the planning committee can speak with the chairman's discretion. I checked it this morning. Yeah. Are you suggesting, Mr. Chairman, that you don't want
That is something which applies before the committee starts speaking.
No, that is not in the Constitution.
It's entirely at your discretion, Councillor Mark. So are you saying you would not like me to speak, because you therefore give me a reason as to why you would not like me to speak? I'm just trying to...
Councillor Quirk, you've only just been re-elected. You haven't had planning training. You're not a ward councillor. You're not a county councillor representing this area. You should not be contributing. You should not be attempting to contribute to this debate. You are potentially endangering this council by attempting to jump in, because if it's perceived that we come to a conclusion on the basis of something that you have said, that makes this council vulnerable in all sorts of ways as far as the decision is concerned. Councillor, if you're not quiet, you will be leaving the room. No, councillor, you don't have an opportunity to speak at this point.
Just trying to help.
Thanks, Chair. So members should have also received a briefing note earlier in the week just to set out what the PPG says in terms of helping local authorities identify grey belt land. And so it's paragraph 005, reference ID 640052025025, which was in that briefing note. Sorry, I will come back to that. So what it says about purpose A, to check the unrestricted sprawl of large built-up areas. The purpose relates to the sprawl of large built-up areas. Villages should not be considered large built-up areas. So what makes a strong contribution? And then it sets out a series of illustrative features. So if it makes a strong contribution, then you might say it's checking the unrestricted sprawl of large built-up villages. This is what the PPG says. Assessment areas that contribute strongly are likely to be free of existing development and lack physical features in reasonable proximity that could restrict and contain development. They are also likely to include all of the following features: be adjacent or near to a large built-up area, if developed, result in an incongruous pattern of development, such as an extended finger of development into the green belt. It then goes on to explain what moderate contribution is, and then weak or none. So weak or none, for example, is assessment areas that make only weak or no contribution are likely to include those that are not adjacent to or near to a large built-up area, are adjacent to or near to a large built-up area, but containing or being largely enclosed by significant existing development. So that's point A. So that's been set out for you previously. Purpose B, to prevent neighbouring towns merging into one another. Strong is assessment areas that contribute strongly are likely to be free of existing development and include all of the following: forming a substantial part of a gap between towns, the development of which would be likely to result in the loss of visual separation of towns. D is to preserve the setting and special character of historic towns, which this particular site doesn't contribute to. So they are the examples that the government sets out. They're not particular. I don't think they're meant to be actually, conclusive, but that's the examples. And then, so D, is preserve the setting and special character of historic towns, which isn't relevant to this particular site. So, by saying it's not grey belt, you are making a decision to say that it's a strong contributor in checking the unrestricted sprawl of large built-up areas for those reasons that I read out, or moderate, or it could be a combination of the sort of between strong and moderate, and the same with purpose B, to prevent neighbouring towns merging into one another.
Is that the end of the point you're making?
Sorry, yes, that's the... Yes.
Right, okay. Councillor Barber, do you want to come in?
Yes, thank you, Chair. I have to agree with Councillor Baldock. I think we're being asked to prove something where we do not recognise the strength of the case either by the applicant or in the officer's report. And I think we are basically trying to jump through a hoop that really, frankly, I don't think is there. I think it's our right to vote for or against this application. If anyone wants to expand on it, I mean, for me, does towns also extend to villages? Because I take it on board that actually it probably does. If all the Kelvin and Hatch and Pilgrim's Hatch were to merge into one with one contiguous housing estate, I think people would say that that was damage that had been caused to the green belt. Frankly, I'd like to ask the officers to tell me which fields and which areas of the borough they actually do think meets the criteria of green belt and not grey belt, because frankly, I think they won't offer me a site if I ask them that question.
And this is a fundamental part of the problem. I mean, all of this wording, we don't have Brentwood evidence, we don't have the work that Brentwood has done, we don't have clarity on If this site, if we tonight were to regard this site as being a grey belt site, what other sites, what percentage of the entire green belt in the borough would therefore be grey belt as a consequence of the decision that we're making tonight? We don't know, and no officer knows because that work hasn't been done. I mean, that's the position we find ourselves in, but it makes it extremely difficult for any member of this committee to feel confident that this site is grey belt and not green belt. Notwithstanding the wording, I mean, I'm not ignoring the wording. I've paid attention to the wording. As I say, the wording is defective, it's circular, it doesn't stand up, and any attempt by anybody to build further clarity on top of that wording is frankly doomed to fail. And as I say, the person I quoted earlier on was saying that that is so. So I can't build an answer, I can't build a final conclusion on a question mark. We do, however, have some clarity in terms of HP10. We have clarity on HP10 because we're being told that the council's policy is that new gypsy and traveller sites have to come forward either through the planning process or through as a windfall site by abiding by HP10. And as has already been said by Councillor Barber and has been agreed with by me, this site, well, first of all, it didn't come through the planning process. I mean, it was just a green field 6 weeks ago. So it definitely didn't come through the planning process. It's an encroachment on a green field with a planning application put in speculatively. So it hasn't come through the planning process and it doesn't abide by HP10. This is the avenue that this council itself says we should be looking at in terms of assessing gypsy and traveller sites. That's where we are. That's why the motion is a motion for refusal. So, yes.
Sorry. Yes, I'm trying to be as helpful as I can. In terms of the reasons which I believe have been put forward, firstly, it's in relation to the understanding of the conclusion you've reached that it's green belt. Your officers have clearly assessed this mindful of what the NPPF says as a material consideration. And in essence, you've been asked to deal with those 5 purposes, or the 3 purposes that constitute that assessment for grey belt, and an answer to each of those, which I'm not sure we fully itemised as to how the purpose of checking the unrestricted sprawl, preventing neighbouring towns merging into one another, and preserve the setting and special character of historic towns has been dealt with. But I do appreciate that one of the other reasons was in respect of HP10, which you're going to deal with. Thank you.
I'll come back to Councillor Rigby. Councillor Rigby.
Thank you, Chair. Pilgrims Lane and Pilgrims Hatch itself is a deeply historic area and part of Brentwood, which in itself is one of the most historic towns in Essex. Indeed, this particular application is very close to a historic church of great antiquity. And I just wonder, given the proximity of the location to the church, the rurality, the history and nature of Hatch as a part of Brentwood, because although it is a rural setting, it is part of a historic town by definition of Brentwood within the borough, that might assist in taking us forward.
Yes, thank you, Councillor Rigby. You've actually reminded me of something. I mean, again, it's not in the officer report, and I think it should be touched on. I mean, let's look at the name of the settlement Pilgrims Hatch. Let's look at the name of the route Pilgrims Lane. The reason why this town is here is because pilgrims were travelling down to Canterbury. They were going north-south. They were going down to Tilbury to cross over into Kent. And Pilgrims Lane is the route that they followed. That's why it's called Pilgrims Lane. So Pilgrims Lane is that part of the setting and the special character of a historic town? I mean, pretty much every town in this country, except for new towns, are historic towns. They may not be historic. Some of them are more historic than others, maybe, but I think Brentwood is pretty historic. We've got a charter which dates back, was it 800 years or something? It is also, as I say, the Pilgrims route is a fundamental reason why the town is here in the first place. I think the point there would be, to go back to the point that's been raised by Mr. Bell. So paragraph 143 of the National Planning Policy Framework and the three elements which we're supposed to be looking at in terms of deciding whether this is green belt or grey belt. First of all, I think the nature of given the changes that have been made, the nature of the phrasing of A and the checking the unrestricted sprawl of the large built-up areas, can we have quiet, please? Is uncertain because it's uncertain what constitutes the unrestricted sprawl of large built-up areas and what we could do or what we should be doing to check it. I also think, as I say, I think the point that Councillor Rigby's made in terms of historic sounds, it's disappointing that this report doesn't touch at all on the historic character of Pilgrims Lane, which is literally right next to this site and which we have heard from the neighbour is being damaged by the occupants of this site. So, as far as I'm concerned, there are definite question marks as to whether paragraph 143 of the National Planning Policy Framework, A, B and D, are actually adhered to on this site. And that is the reason why I'm regarding it as being a green belt site rather than a grey belt site, and the rest follows. No, Councillor. No, Councillor. No, Councillor Wagner. No, no. No. Yes, thank you.
You have dealt with the issue of grey belt. There have been a number of other grounds of refusal mentioned by the committee, and they should be included. I simply want to make sure that that error doesn't get committed. Thank you so much.
We will, if people, I know people are trying to be helpful. If people keep on shouting out, we will have to remove them from this committee room. We're trying not to make things more difficult for this council. At least I'm assuming that is the case. I don't have anybody else who's down on the list to speak. We've had comments from officers. Shall we go to the vote?
Go to the vote? Yeah. We go to the vote now. Right. Thank you. Would members please indicate for or against the motion when their name is called? Councillor Minot.
For.
Councillor M. Cuthbert.
For.
Councillor Baldock.
For.
Councillor Barber.
For.
Councillor N. Cuthbert. For. Councillor Gelderbloom. Councillor Marsh. For. Councillor Mayo. Councillor McShane, Councillor Naylor, Councillor Patel and Councillor Rigby. Thank you. That's unanimous.
Thank you for that. Yes, and I always like to say if it is unanimous because I think that sends a clear message. We're all together. If you're requesting a toilet break, yes, absolutely. Yeah. We've got the committee present. I'm assuming that those who want and need to be in this room for item 5 are in this room. Does anybody know if somebody's not in the room who's not on the committee who needs to be in the room for item 5?
Well, she's not a member of the committee, so it's not a problem.
She's not.
Member
She's
of
not
the committee,
the.
it's not a problem.
Yeah, for that item. Right. Okay. Well, I'll actually just check. So I'm assuming that both Linda Beanie and Brian Woods are in the room. Yes. Right. Okay. We're okay in that case. Right. So we will go to item 5. This is the application for 5 acre farm of Worley, Great Street in Great Worley, and this is for a material change of the use to the land to a mixed use of agricultural land and a gypsy traveller site comprising 4 pitches. Permission is being sought retrospectively, and this is application number 25/00494/FUL, and as before, the case officer is Leanne Richardson. Ms. Richardson.
Thank you, Chair. As with the previous application, the site is within the green belt and we need to make an assessment as to whether it constitutes grey belt land. But I won't touch on that in this presentation because we've heard that and discussed it quite a lot, yeah. So moving on. So the site comprises a rectangular parcel of land to the south of Great Worley on the east side of the B186. Mangrove cottages lie to the south of the site, with dwellings on Bird Lane further north. Open fields lie to the east and to the west of the site. The next few slides are just photographs showing the site. So this first one was taken in September last year. Just shows the site as laid out. So that this is the site as currently laid out. So this shows plot 1. Then we have plot 2. Plot 3. And plot 4. And those 2 photographs just show the central paddock in the centre of the site as currently proposed. So it's important to note the planning history of the site and consider the material changes that have occurred since the termination of the previous scheme. So the amendments include a reduction in scale and intensity. So the current proposal reduces the number of pitches from 8 as originally built to 4, and the current scheme introduces a central paddock. The following changes to the planning policy for traveller sites definition: more households now qualify under the revised definition, resulting in an increased need. Introduction of grey belt and a greater unmet need. So in terms of the current application, each pitch would have 1 static caravan, 1 touring caravan and 1 day room. The day rooms at each pitch would not be occupied for overnight accommodation. Soft landscaping is proposed along the boundaries of each pitch, and the details would be secured by condition. The amendments seek to overcome the previous reasons for refusal. There's also been a material change in national policy since termination of the application, and all of the above factors were in favour of the scheme. So we've already heard that the council has an unmet need of traveller sites, and this is relevant again in this current application. Whether the site is within a sustainable location is a matter that has previously been addressed by the Inspector in the previous appeal. The Inspector's decision is a material planning consideration in the assessment of this current application, and the Inspector concluded that the site is sustainably located. So moving on to the very special circumstances. Again, these would only be relevant if the scheme was within the green belt and not considered to be grey belt. So the site is occupied by an extended family who are Irish travellers, and officers are satisfied that the occupants would meet the gypsy status as defined by the PPTS. A personal circumstances statement has been submitted which states that a number of the occupants, including children who attend local schools or are homeschooled, suffer from healthcare needs which are exacerbated by the uncertainty of the current housing situation. The personal circumstances of the applicant and extended family weigh in favour of the development.
Sorry, could we just go back to, we seem to have skipped from the rest, thank you.
Sorry.
So we can see them.
In terms of the impact on the character and appearance of the area, the report sets out how the relevant criteria of policy HP10 has been met. So the Inspector in the previous appeal decision concluded that the development would have a significant adverse impact on the character and beauty of the countryside. However, in this case, there are material differences between the current proposal and the previous scheme, notably a reduction in scale and intensity of the development proposals. So whilst the character of the area is rural in nature, given the amendments and the ability to provide mitigation through existing and proposed boundary planting, which would aid in softening any impact, officers consider that the adverse effects on the character and appearance of the area would not be so significant to justify refusal of planning permission. So, yeah, in terms of, just to conclude, the PPTS definition has been met by the applicants. There would be no significant harm to the character and appearance of the area. There are no technical objections to justify refusal of planning permission, and the scheme would address a shortfall of accommodation needs for the traveller community. Thank you.
Thank you for that. Right, so the first person we have to speak is Linda Beanie from the Great Worley Conservation Society.
Thank you, Chair. Each of you will have received our barrister's letter and a synopsis of that letter outlining why GWCS strongly disagrees with the officer's assessment and recommendation to approve the planning application before you this evening. GWCS believes that the findings of the Independent Planning Inspector, February 2023, have been largely ignored. In a nutshell, there was harm of inappropriate development, further greenbelt harms to openness and encroachment into the countryside, as well as harm to the character and appearance of the countryside, contrary to HP 10. In the inspector's own words, a textbook example of unauthorised development. The reduction in the number of plots is simply not significant enough to offset the impact on the green belt I have just described. There is no substantial material difference offered in the revised application. The size and scale of the development remains the same. GWCS disagrees with the characterisation of the land as grey belt. The grey belt is intended to apply to land within the green belt that comprises either previously developed land, PDL, or land which does not contribute to meeting green belt purposes, para 143A, B and C of the NPPF. The land in question clearly contributes to Greenbelt purposes as concluded in the planning inquiry I've referred to. This was farmland before. The report's analysis of Greybelt status is light touch and unspecific. It allocates just one sentence, para 619, setting out why the site is within the Greybelt, and fails to take the correct approach to the classification by not considering the wider context within which the land is situated. Should the planning application be approved, then the floodgates to further applications in the Brentwood area will surely follow as night follows day. You should not allow Brentwood to be used as a test case, given the resounding judgment against previous applications and the outrageous pattern of non-compliance with every finding over the last 5 or more years. This is a critical decision for the Council. You have a choice. Either you accept the robust analysis and independent findings of the planning inquiry, which found strongly in favour of the Council, or you ignore this and accept the ill-thought-out categorisation of the land as Greybelt and all that entails. If you choose the latter, not only will the floodgates open, but a huge amount of time and money will have been sacrificed. Add to that the increase in expenditure that would arise for the Council if residents and GWCS decided that legal action was required because of today's decision, the costs of which would greatly outweigh those of an appeal by the occupants, which, according to our barrister, the Council would in any event be in a strong position to win. You have an opportunity tonight to make the right decision for local residents and for Brentwood. Thank you.
Thank you. Thank you for that. Right, the next person to speak is the agent, Brian Woods.
There. Thank you. I had a speech written out, but I heard all that went before the last item, and so I think I need to address a few issues in a different way. Reference was made to sustainability on the other case, and there wasn't a bus stop outside. There's not a bus stop outside this site either, but the previous inspector on the sustainability issues, as set out in paragraph 6.30 of your officer's report, found the site to be sustainable. And I think reference was made, oh, well, there's no case law on this. There have been numerous planning appeals, but there is one case, and perhaps your legal advisor will be aware of this, and this was Mole Valley District Council versus the Secretary of State, and it related to a Greybelt decision by an inspector, and it was challenged by the District Council on 3 grounds. And all 3 grounds were dismissed and the decision was upheld. That site was in a very rural area, no bus stop from probably a mile away. And so I think it's important to bear that in mind. What has been helpful is the PPG, which elaborated on what you look at in relation to Greenbelt. And the case officer's report before you is pretty comprehensive in this matter. One member raised the query and said, well, look, you know, if this is Greybelt, everywhere's Greybelt, and so there'll be a plethora of applications we can't resist. Well, that, of course, is plainly not correct, because if your council could demonstrate a 5-year supply of pitches, then you would not be moving on to considerations of Greybelt because it wouldn't be able to fulfil that criteria. So that's the way that you can deal with things in that approach. There was mention of the written ministerial statement. I'd just like to point out that was supposed to be reviewed after 6 months. It was brought in 2015, and we've had numerous iterations of the framework since then, and that opportunity was not taken by the previous government or the current government, which is a shame, really. So, if you decide that for whatever reason, and I think it would be the wrong decision, if you decide that the site does not fall within the definition of grey belt, then of course you will be, you will be going on to consider very special circumstances. And in that respect, no 5-year supply, general need and failure of policy, personal need and children. And of course children, the best interest of the child is the primary consideration, which carries the same weight as any harm. The occupants of the site will be very grateful for a planning permission so they could continue their life, and they have amended the proposal substantially from what was there before. So I ask you, please grant planning permission. Thank you for hearing me.
Thank you for that. Right, so we have both Councillor Baldock and Councillor Marsh present, who are ward councillors. I don't think, and it's not personal on anybody, but I don't think there's anybody who isn't on the committee who has a right, it would be appropriate for them to speak given the role that they're playing. That's not attempting to stop anybody from speaking. They would be able to speak if they were here. Councillor Murphy isn't here. We don't have a statement or anything from Councillor Murphy, do we? No, okay, that's fine. So Councillor Baldock and Councillor Marsh as ward councillors, does one of you want to lead off the committee discussion?
Yes. Obviously, we've gone on about Greenbelt for maybe an hour, and the ambiguity of it being Greybelt. But hopefully, referring to the inspector's report that has been referred to already, and I'm just quoting from this, it seems to me is exactly the sort of parcel of land that Greenbelt was intended to protect. Now, I know the goalposts have moved a bit, but how can something in the inspector's opinion be exactly, in other words, category A Greenbelt, be moved into Greybelt? That's really confusing to me. To me, that says these are the people that we're frightened of costing the council hundreds of thousands of pounds if they disagree with us, right? But this guy said exactly. So surely we can refer to that and go, no, one of your colleagues said it's exactly the green belt. That's one thing. The other thing is the footpath. I see very little mention of the footpath other than to say that it exists. But again, see, what I love about this is I can refer to this, is in the previous inspector's report, and I don't think anything's changed in terms of footpaths when it comes to 5-year plans and grey belt and stuff. There is clearly harm to the footpath in terms of reducing the quality of the experience of using it, which adds to the harm to the character and appearance of the area. Now that's after several paragraphs in basically where he says that they've just built all over the footpath, they've moved the footpath, they've put a gate over the footpath, they claim, the residents, the neighbours have claimed that it's sometimes changed. The applicants say it's not, but the inspector, now this isn't me or the applicant or the neighbours, the inspector says that he saw a padlock on the chain, which seems odd if it is never used. So that's, again, this is the inspector. So these are the people that we are answerable to if we make the wrong decision. So there's two cases there that we would go with. Now, I don't want to go on too much, and I could come back to another two if you like, if you want to carry on and let other people speak.
Don't have actually, other than yourself and Councillor Marsh, nobody's indicated. Oh, Councillor Naylor now has, but there isn't a long list. If you want to carry on, by all means.
The other one is the unintentional, the intentional authorised development. Again, referring back to the previous report. He basically concludes there's been massive occasion of that on this site already. Yes, I know they're going to say they're reducing it, but it's still hardcore across the entire site.
And it says this is a textbook example development that was carried out intentionally and in full knowledge of what they were doing, but what they were doing by the occupiers. And here we come to weight, what weight we have to give things, and given in mind that these are the guys that tell us that we've got to pay penalties and that, I shall give considerable weight to the WMS. Now, nothing's changed in terms of WMS. Yes, it should have been reviewed, but it wasn't, so therefore it hasn't changed, right? So there's weight to that also. And this is all in a colleague of who will be reviewing our decisions. It just beggars belief that none of this has been mentioned. The 5 year, it says here, I know the goalposts have moved a bit with the 5 year, but in this report, the harm identified to the greenbelt openness of the countryside and the matter of intentional unauthorised development are not clearly outweighed by the lack of 5 year supply of sites and the lack of alternative site for occupiers. But it does go on, previously saying that Brentwood are already engaging with their local development plan. I've got another one about families further on, but I'll leave it there for now.
Thank you for that. Councillor Marsh.
Could I just clarify a couple of things first? Paragraph 6.4, it said the government's overarching aim is to ensure fair and equal treatment for travellers in a way that facilitates the traditional and nomadic way of the life of travellers while respecting the interests of the settled community. Does the settled community refer to the residents or something else?
Who wants to answer that?
Sorry.
So the settled community refers to all other borough residents.
Okay, so it specifically refers to the residents. Okay, so we need to respect the traveller's way of life, traditional way of life, which is nomadic. On this site, we're proposing 4 static caravans, 1 touring caravan and 1 day room for each site. Now, I'm not quite sure why nomadic people need a static caravan and a touring caravan, but what confuses me most of all is the day room. A day room to provide day-to-day facilities. I'm not sure what day-to-day facilities most of us would have, or certainly the travelling community couldn't accommodate in a static caravan and a touring caravan. There are many people who live in a studio flat or a very small one-bedroom flat. So my concern is what the actual function of the day room is meant to be in the future, particularly coming from a community have shown a fairly flagrant disregard for the law to date.
Thank you, Councillor Marsh. I'm sort of assuming nobody has the answer to the day room question, at least none of the officers. That would be the applicants themselves. I mean, if any officer wants to.
Thank you. So day rooms normally contain items like washing machines, tumble dryers, like a utility room somewhere for storage, that sort of thing, of items relating to or ancillary to their living accommodation.
Okay, thank you for that. Councillor Naylor.
Yeah, mine was just a quick point on what Councillor Baldock has already mentioned about the footpaths, in that ever since the site has appeared back in, I think it's 2019, to the present day, the footpath has not been respected. The foot style step has been ripped apart, and a piece of plank of wood's been put vertically across, so you can't even climb across the fence. There's mention of a chain link, and there's a piece of electric fencing as well that runs along the footpath. So what can be done to ensure that there's conditions in this application, but there's no sorry, I think Steve Bell was indicating he wants to speak.
Thank you very much. With regards to the public right-of-way, the county as a highway authority have the powers under the Highways Act to ensure that it's free and available and unobstructed, and they can deal with that via a multitude of ways. And the County under the Highways Act has that power. I used to serve those notices as an ex-highway lawyer, so I know that to be the case.
Is that all, Councillor Nair? It is. Councillor Wrigley.
Thank you. I have a couple of questions. First question is in relation to the letters of representation that were sent. It stated that 33 households wrote with a wide variety of objections, which are under-summarised on page 33 of the paper. What percentage of the local population of the area does 33 households amount to? Is that a significant majority of the residents, an absolute majority? Perhaps the officer could conclude, answer that question as to whether or not that's that. Secondly, we heard from the applicant in relation to a case, Mole Valley, which he referred to. I myself am not familiar with that case, but I'd like to ask the legal officer if he is indeed aware of it and what that means for this application before us today, because it has been raised in discussion and I think that does need to be answered. So first question on the number of houses, on the number of households and its relationship to the local area, and the second question in relation to the case cited.
So is there an answer to the question about the number of representations, the 33 responses?
I suppose it's a question of where do you consider the local area to be, so we can't give you a definitive answer on that. Obviously, the full responses, which would include the address, postal address, doesn't it, are on the planning portal, so that's something that you could judge for yourself. But we haven't made that assessment of how many. We haven't counted off the most local houses and checked those against the responses that we've received.
Yeah, I mean, in terms of the High Court case, the Mole case, I'm aware of it, in which the High Court confirmed that appropriate development does not harm the Greenbelt. I'm not sure the issue of access here is the same as the previous one. I think it was addressed in the inspector's report, if I'm right. Caroline, you pointed out that the issue of access in this particular case from the inspector. With regards to whether the access is the same issue as in the previous matter before members for this particular application. Okay. What's the issues with regards to access to this particular site? There isn't any.
So were you saying that the Mole Valley case had to do with access, a part of that had to do with access, but there isn't an access issue? I mean, I don't think anybody said there is an access issue here.
I think that's the case, yes.
Okay, I think that's useful. Councillor Gelderman.
Thank you, Chair. I just wondered if Essex County Council are aware of the public right-of-way issues, because it is quite a serious offence and can possibly give weight to any decision that is made, I should imagine. Obviously, it impedes on people's pleasure as well, and I just wondered if Essex County Council, if the council made them aware of the issue. Thank you.
Again, we haven't got anyone from Essex County Council here. I mean, it's been an issue for the length of time that site has been there. So, I mean, one would have hoped that there would have been some activity by now. It's obviously rather disappointing that we haven't seen any activity, given that, as we've already been told, it is their responsibility, and if a public right-of-way is obstructed, that's completely unacceptable, and that obstruction has to be removed. I will go to Councillor Barber.
Thank you, Chair. I have to agree, first of all thank Linda from the Great Whalley Conservation Society. I think she spoke very well and advocated the case against this application very well. I did hear and listen very carefully to the agent, and the points that he made. However, I've got to be swayed by what Councillor Baldock said about the inspector's report and the way that that was basically graded as top quality green belt, basically, and it was an egregious incursion into that land. And how that becomes grey belt overnight, going back to Councillor Mayo's point, is simply beyond me. It doesn't make any sense. I noticed in the report there's references to not being near the historical town of Brentwood, but it makes no mention of being in close proximity to the Whalley Conservation Area, where there are a large number of very historical buildings which form a great part of the history of this town. I noticed yet again on this application, despite the fact it's retrospective, that we are still talking about we can condition sewerage handling. There's no details have been provided. I mean, you would have thought that anyone coming forward with an application, whatever the background of the people applying and the type of application, would have actually sorted out the sewerage. That should not be something that's left to after the meeting, the planning meeting, deliberates. And for all the reasons, in terms of the precedent it sets on grey belt, I certainly vote against this application. Thank you.
Thank you, Councillor Barber. Councillor McShane.
Yes, surely we can actually use all the reasons from this first application for refusal for this. You know, it actually just says it was a 5-acre field of grassland, and now it's a mess. I'm just looking at, you know, the latest, when was the latest? 23. It's only 2 years ago when it was refused. And as Councillor Baldock said, it's all the reasons for refusing it were given, and that it's prime greenbelt land with fields all around it. So I will be refusing this as well.
Yes, thank you, Councillor McShane. I would say, though, that these are two different applications and they do have different characteristics, and some of the things which were obvious from the report were problematic with the first application, item 4, are not an issue, or not so much of an issue here. I mean, we have already heard that the inspector's report is material consideration, and the inspector's report says that the site is sustainable. We had significant questions as to whether the previous site was a sustainable location. I don't think that's a question in this case. However, the fact that we, on this site, have an inspector's report does give us a lot of help, because although things have changed since the inspector's report, and yes, what's being proposed is being scaled down, the inspector, as has already been said by others, the inspector did express their support for this site not being, not becoming a gypsy and traveller site, not being a gypsy and traveller site, in very strong words. I mean, one comment that struck me from what the inspector says was that this site is fundamentally unsuited to the use proposed, and the use proposed is obviously as a gypsy and traveller site. Now, the officer's report seems to take the view that with the reduction of what was being proposed on the site, the inspector's fundamental issue is somehow eroded, and so it's eroded to the point where it's not an issue at all, and we can turn around and say, okay, now it's acceptable. That's not, you wouldn't use the word fundamental if that was your attitude. When you say fundamentally unsuited, you're saying this is a site that should not be used for that purpose. This is not really negotiable. The slight changes are not going to make a great deal of difference, at least as far as that particular inspector is concerned. Obviously, a different inspector might take a different view. But the comments which that inspector made are very clear, they are material, and it's very obviously against the idea of this site being a gypsy and traveller site. I mean, I would certainly say that as far as this site is concerned, I've got concerns over HP 10, paragraph D. I've got some concerns over HP 10, paragraph G, as we had with the previous site. As I say, it wouldn't be HP 10, paragraph A, as far as this site is concerned, because there isn't the sustainability issues on this site as there are on the previous site. But there are two parts of HP 10 which are certainly issues as far as this is concerned. We have the written ministerial statement about textbook examples of unauthorised development, and this is an absolute textbook example of unauthorised development. We and we have the other statements, and Councillor Baldock has been very assiduous in passing on some of those statements to us by the inspector. So the previous inspector was extremely clear. The other point that we've got here is the fact that although some circumstances have changed, and obviously the biggest change is grey belt, let's just set that aside momentarily, the other changes are not the kinds of changes. I mean, the inspector themselves, to some extent, the inspector themselves made it clear that these were not the sorts of things that would change the consideration. That the council didn't have a 5-year land supply of gypsy and traveller sites at the point that inspector's decision was made. So to ask us now to approve this as grey belt, and partly on the basis that we don't have a 5-year land supply, is going against what the inspector said, and what the inspector said is material. So I'm giving significant weight to what the inspector said, with the understanding that things have changed. And obviously grey belt has changed, and we've gone through that discussion as far as the previous application is concerned. As far as I'm concerned, as far as this application, this site is, when we look at this site, my question is whether this actually does do what NPPF paragraph 143 A is saying, which is the bit which is talking about unrestricted sprawl of large built-up areas. Now, okay, we've been told that the PPG says that villages aren't large built-up areas. The problem is that we go back to this question of unrestricted sprawl, and particularly, one would have to say, what constitutes unrestricted sprawl and what constitutes the genuine danger of unrestricted sprawl has changed, in my view, materially changed, as a consequence of the government's own changes to the National Planning Policy Framework and the grey belt wording. I mean, under Greenbelt, the chances of unrestricted sprawl were very little because Greenbelt was pretty restrictive. Grey belt is not restrictive at all. And the chances of unrestricted sprawl are immensely increased under grey belt legislation. There was some discussion at an earlier stage, and a view was expressed that having sites which were not immediately next to existing built-up areas meant that they might fall into the category of grey belt because of the way that grey belt was being interpreted. Well, I can see that might happen, and you can see that you might define sprawl in that way, but clearly, if it's okay to build on the field next but one to your built-up area, you can then talk about infill on the field between the bit that you've built on and built-up area, and then you can do a next but one, and you can hop down the road next but one, next but next, and that's your unrestricted sprawl. That is exactly what that would cause. That would be the consequences of that wording. So, and similarly, as far as Great Wall is concerned, and we've already heard the historic nature of Great Wall, and we're fully aware of the historic nature of Great Wall and some fantastic buildings in the conservation area. Again, it's not a historic town. Is Brentwood a historic town? Brentwood and Great Whalley will become all part of one large built-up area under grey belt legislation if everything in between becomes grey belt, and we have to say yes to it. I genuinely cannot look at paragraph 143, NPPF paragraph 143A, and convince myself that saying yes to a site like this and reckoning that this is grey belt helps check the unrestricted sprawl of large built-up areas. Even if it's next to a village, even if there are gaps. I genuinely can't see that. So as far as I'm concerned, we're once again in a situation where, despite the advice that we're being given by the officer, I think we should be looking at this as a greenbelt site. We have what the inspector previously said about it, with the understanding that grey belt has come in and various other changes have happened in terms of 5-year land supply, but what the inspector said is material. We've got written ministerial statement, which is also material. We've also got the possibly two, certainly one, I would say, sections of HP 10, and that would be the certain one, as far as I'm concerned, would be HP 10D, but I think HP 10G as well, because you have neighbouring properties. All of those are reasons, as far as I'm concerned, to move this for refusal. I'm happy to move this for refusal. Again, I don't have a seconder at this point, and I'm happy to have a cross-party seconder if somebody wants to come forward. Councillor Baldock. And yes, officer comments.
think there are any comments specifically on this as a specific question. The committee has expressed that it does not consider that paragraph 143 A, B and D, it meets those tests. So it's not green belt, and therefore you are considering it grey belt, sorry. So you're considering it under green belt, and HP10 is the policy that you are considering sections D, E and G.
I don't think I mentioned E.
Just D and G.
Sorry, I'm just finding HP10's eluding me again. Okay, yes, the site would not lead to the loss of or adverse impact on important historical and natural environmental assets. Well, certainly the historic nature of Great Whorley and the fact that it's a conservation area, I think HP10E definitely could apply. You're absolutely right. So, yes, HP10D, HP10E and HP10G, as far as I'm concerned. Does any officer want to come back further?
So just to add to that, the committee is giving significant weight to the ministerial statement and to the previous appeal inspector's report decision. And just to be clear that any of the very special circumstances that have been put forward by the officer don't overcome that harm that you've identified in that policy and those ministerial statements, or the ministerial statement.
Okay. Does any member want to come in? We will otherwise... Councillor Baldock.
With regard to the very special circumstances, now, obviously I am obviously clearly still a novice, and this is only from the previous report, and I realise that the world may have moved in 2 years and there might be entirely different people there, but the previous inspector goes on for 6 pages where he tried to establish what families were there, what ties they had there, what ties they had to each other. And on one of his pages, and again I'm quoting him, no one apparently talked to anyone else when they were there. And it would be better if they did, when they moved on, that they should move on to pitches of 1 or 2 rather than 8. I agree that they're only saying 4 now, because they were not one community. They were separate communities who didn't talk to each other. I think he comes to that conclusion because they all denied knowing that they should have had planning permission before moving on there, which he mentions earlier in his report. Again, this is the inspector's report. So I would question the officer's conclusion that there's special circumstances, given that it's only been a couple of years since this report. Thanks.
Thank you, Councillor Baldock. Councillor Rigby.
Thank you, Chair. Again, it's been a really good and strong series of contributions from across the Chamber. I listened quite carefully to what the objectors from the Great Whorley Conservation Society had to say, and obviously they sought the advice of Junior Counsel in relation to this application. On reading the letter and the inspector's report, which was appended to that, I thought that paragraphs 12, 13 and 14 of Council's letter were particularly useful, alongside the officer's detailed briefing note which was sent round to us, which obviously was very helpful, and the officer's report that was contained therein. So I've had a balance of views put to me. We've had the benefit from the applicant, we've had the benefit from objectors, we've had a wide range of contributions from very experienced councillors from across both sides of the chambers on this issue, and I believe that a motion for refusal is appropriate.
Thank you, Councillor Rigby. And something I was actually going to say with the previous site, obviously, since we've had 2 Gypsy and Traveller sites. I certainly am very conscious of our duties under the Equality Act 2010. I'm conscious of what the planning policy for traveller sites says. And I'd also, just personally, like to say that when we had the Accord year at the council, I was vice chair of planning at that stage, and we had the Roman Triangle site, which was a Gypsy and Traveller site, came back to the planning committee, which had previously just been given temporary planning permissions. And I was only too happy at that point. On that site, in the conditions of that site, the circumstances of that site, and obviously this is long before Greybelt came on the scene, I was only too happy to say yes to a Gypsy and Traveller site as it was on that location on the ground, to basically say, okay, yep, it's fine. I'm sure the neighbours weren't particularly happy, but on that site it was an acceptable Gypsy and Traveller site from my point of view. So there's absolutely, and I'm sure I'm speaking for most people in this committee, everybody on this committee, hopefully, we don't have objections to Gypsy and Traveller sites, and this council is going through a process of identifying new sites for Gypsies and Travellers. The unfortunate sequence was that the council adopted a local plan and then the goalposts got moved in terms of Gypsies and Travellers. There's a very little you can do about that. On the spur of the moment, you have to go through an extended process to find new sites. That's what this council is doing. That's what we will do. We will find new sites, and there will be appropriate locations for Gypsies and Travellers to stay and to live in Brentwood. But the suggestion that's being made tonight is that this is not an appropriate one, and this application should be refused. So we've had the motion for refusal, which has been seconded, and we will go to the vote, I think.
Thank you, Chair. Would members please indicate for or against the motion when their name is called? Councillor Minot.
For.
Councillor M. Cuthbert.
For.
Councillor Baldock.
For.
Councillor Barber.
For.
Councillor N. Cuthbert. Councillor Gelderbloom. Councillor Marsh. Councillor Mayo. Councillor McShane. Councillor Naylor. Councillor Patel. And Councillor Rigby. Thank you, Chair. That's unanimous.
Once again, unanimous, yeah. Okay, actually. There is no other item on this agenda, so the meeting is over. Thank you.